Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their. I'll sit.
Thank you. Please be seated. Good morning. Welcome to the Kansas Supreme Court. Glad to have so many in the courtroom this morning, as well as I assume we have some listeners online. I know we have at least one that I'll talk about a little more. I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
The first case on the 9 a.m. docket for Wednesday, December 14th, 2022 is appeal number 123260, State of Kansas versus Maria Acadia Ruiz, Ford County, briefs both sides.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Maria Ruiz. And I'm ready for argument, and I would ask the court if I could 3 minutes for rebuttal.
Brandon, thank you, Mr. Dunn.
May it please the court. Good morning. The state appears on behalf, goodness, Jody Litvin appears on behalf of the state, and I'm present and ready for argument.
Second case, appeal number 125500, in the matter of Mitchell J. Spencer, original action and attorney discipline, no briefs filed.
Please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
May it please the court. I'm John Rapp. I represent Mitchell Spencer. He's also present in the courtroom, and we're ready for argument.
Third case is appeal number 125499, in the matter of Jeff L. McVey, original action and attorney discipline, no briefs filed.
Gail Larkin, Disciplinary Administrator, appearing on behalf of the Office of the Disciplinary Administrator. I'm present and ready for argument. And Chief Justice, may I request 3 minutes for rebuttal? Thank you.
Members of the court, Tom Berscheid here on behalf of his client, Jeff McVey, and we're ready for argument. So.
And our final case is appeal number 125622, in the matter of Isaac Henry Marks Sr., original action and attorney discipline, no briefs filed.
Members of the court, Kathleen Selzler-Lippert on behalf of the Disciplinary Administrator. Present and ready for argument. I would request 3 minutes for rebuttal.
Good morning, members of the court. May it please the court, Isaac Henry Marks Sr. I am pro se. I am present and ready for argument.
Your Honor, that concludes the docket for the week of December 12th through 14th, 2022.
Thank you, Mr. Shima. The reason I said earlier that I knew we had at least one online observer is that it is our colleague, Justice Wall. Justice Wall is under the weather and so not in the courtroom today. Fortunately, he fills up to listening to your arguments, and so he is doing that. We've had a couple of times this week where, because this is our third day without him being in the courtroom, we've had a couple of times when he's emailed us questions, so he is actively listening. But just to make clear, he will be participating in the decision-making in the case, our conferencing, as well as in the writing and finalizing of any decisions that we issue. For those who are watching and who may not be familiar with the court, I will explain that the court is familiar with the cases. We have read briefs, we have read records or portions of records. We have read decisions that may impact the case and done other things before we enter the courtroom. So there will be times that we're looking at our computers, at our papers, either taking notes or refreshing our memories about some of those things we have looked at so that we can better understand the arguments that attorneys and others are making to us. It just helps us with our assimilating all of the information that relates to this. But we do want to assure you that we are actively listening when we're doing that. We are paying attention. So with that, I will call the first case 123-260 State versus Ruiz.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Maria Ruiz. I wanted to get my computer set up. It came in handy yesterday.
This is kind of your time slot. I was thinking, start off each morning with your argument. So
We're here today with just a brief overview. Ms. Ruiz owned a restaurant in Dodge City. She fell on both personal and business hard times and fell behind in her taxes, took efforts to pay them, and was ultimately unsuccessful, however. Rather than the statutorily prescribed methods of going about this, the Attorney General's office came up with a novel theory of a way to prosecute this, as both under the Kansas Retailer Sales Tax Act and under our criminal theft statute. And apparently, press releases from the Attorney General's office indicate this is not the only time they're doing it. This is kind of a new thing.
When you say it's kind of a new thing, I was wondering, is there a history of this, or is this, and I might ask Ms. Lifkin that, I'm maybe just curious, but has this been done in the past where in a tax collection case, they've also filed theft? Or
there are other, according to the press releases from the Attorney General's website, there has been more than one of these types of cases. I had never heard of this before.
right, okay.
And I think they admitted that, and I believe the testimony of one of the revenue agents in this case was, I have my supervisors with me. This is a new thing that we're doing with this. So I think it's pretty obvious. The legislature never intended this. Retail non-payment of taxes by the statute is a misdemeanor under the retail sales tax chapter. And I took a look last night just out of curiosity. It was one of those things at chapter 79 in general. And there are a lot of different other taxes that have penalties. Most all of them are the same type of penalty as this, where it is a misdemeanor punishable by either a month, 6 months, or up to a year in jail, along with some sort of fine. There is one exception to that, which my office was familiar with without looking at the Retailer Sales Tax Act, and that's the Drug Tax Stamp Act, where it is a severity level 10 felony if you don't have your proof that you've paid the drug tax. So we know that the legislature can make it a felony not to pay your taxes because they did it in that situation. But every other tax that I've looked at in chapter 79 at most is a misdemeanor. There's even the motor vehicle sales tax where it's just a fine. So I think it's clear it was never intended for this. This is an executive situation where they've decided they want a harsher penalty for failure to pay Retailer Sales Tax Act. So I don't think it was supposed to be that way. I think it's improper. I think the place for this is to go over to the legislature. If you want to get a change in a penalty, is to try and see if you can convince them of that. Today, I provide this court with two different ways to stop this sort of executive overreach. And the first also involves a statute that this court has not directly examined since it was passed with the recodification, which is the general specific offense statute, for lack, just to call it that, because that's what it did. It codified the general specific offense doctrine. It's 215109D.
Can I ask you just a general procedural question or to that? Do you believe that issue was preserved below?
I do. I think this is a situation where, and I, with all due respect to the district court, because they have a lot of cases that go in front of them, they have a lot of snap decisions to make, where sometimes terminology gets mixed up and analyses get mixed. I mean, I can look at cases back before where duplicity and multiplicity used to get confused all the time. The judge below, the district judge in this case, did a general specific analysis. She called it multiplicitous. She really did a general specific analysis. She said the legislature intended for this to be the punishment. And so I think regardless of the fact that she said, oh, we don't need to even look at that, that's what she did. And so it was examined below, the analysis was done, so I think it was preserved for appeal. Furthermore, I think this is, if we want to look at it another way, this is a right for the wrong, or this court can affirm right for the wrong reason.
Along those lines, do you think the court?
Yes, I do, because I think this is an issue that is of statewide importance. There was no reason to really kick this can down the road when it appears from the press releases that I've looked at, that this is an ongoing situation. Furthermore, again, it's an issue of statewide importance, because if the state can do this in the retailer sales tax situation, they can do it under just about any other tax situation in the state. They can do it for income tax, compensating use tax. They can do it for liquor tax, club liquor tax. It just applies across the board. And frankly, taken to its most logical extreme, any debtor in a contract situation, all of a sudden, someone doesn't perform, they've exerted unauthorized control over someone else's money that they were given and didn't perform. All of a sudden, you've transformed all of those into thefts. So this is something that really needs to be looked at, this theory that you can transform a debt into a theft.
We have case law that establishes that one co-owner of property can commit theft against another co-owner of property. Is this analogous to that?
No, not at all. And that's moving in. That's my second issue, but
Sorry, I'll let you.
no, that's fine. But in that situation, we had, and I assume you're talking about the sheriff's case, where the sheriff collected something that was supposed to be turned over to the state, and they both had an interest in it. Here, I think the easiest way this court could look at this is to say the state doesn't have the interest yet. Money is, in dollars, currency, whatever you want to say, is a fungible good. You don't, when you go to the store, you don't say, I want this dollar bill, this $20 bill, that's for this debt. It's any $20 bill. So the fact that at the point of sale, you collect some money, and yes, at some point you're going to have a debt. That's no different than when I get a paycheck or you get a paycheck from the state, that all of a sudden they have an identifiable interest in dollars out of that, specific dollars out of that paycheck.
But the state can collect on that debt without getting a judgment on it, can't they?
Sure.
That indicate some interest in the property statutorily?
No, there's a severance between those two. The money that's collected at the point of sale is a different thing. Just like when you get your paycheck, you don't have to open a separate account and say, this is the money I'm going to pay at the end of the year to the federal government and the state government. Or if you lived in KCMO, to the city of Kansas City, Missouri. You don't have to have a separate account for that. You owe a debt later on. And they can collect on that debt later on, but not that specific dollars that came from your specific paycheck at that point in time. I don't think that's the same ownership, that same type of interest that we're talking about.
There is a distinction in sales tax over some other types of taxes, though, in that, in a way, the merchant or the business is acting as an agent of the state to collect the tax. So they would not be charging you or I as a customer for that amount of money, that tax, except they're being told by the state to charge it for the state. They collect whatever that tax is for the state and hold it. So is that a distinction that makes?
No, because I think that's the same situation with like excise taxes on liquor stores. They have to collect that.
I think there are other comparable taxes, but there are others where we don't do that.
No, and yeah, I understand that, but I think that's a distinction without a difference. Ultimately, again, money is a fungible good. It is not, if you back in the Middle Ages, and you were paying a particular pig and for a debt or a horse, and the crown could come in and say, you owe me that horse, that's different. But that's not how it works with money. It's a pool of money that you have, that debt that you later can pay out of whatever money you have at that point in time later.
What would, to that end, what would happen if a taxpayer told the government, I forgot to collect sales tax, sorry, you'll have to go get it from my customers. Here's all the receipts, you can go collect it from them.
That's the debt is the collection of it. The debt is on that statutorily is from the customer to the retailer. So you can't say state, you get to go do that.
I understand that, but let's just say, what would the state's response be?
No, I think it'd be like any other civil suit when you get a judgment against somebody.
The state would say, you owe me that money. I don't care whether you collected it or not. It's a debt.
Just like any other civil debt, if you went and said, well, someone else did this, no, you get to go after them later. The judgment's against you.
Doesn't that suggest that it's a debt as opposed to some kind of a bailment you're holding my property in trust for me?
Yes, I agree with you. And that's why I think that statute makes a distinction there. But I think it applies to all taxes, but that's why I pointed out that the Retailer Sales Tax Act specifically gives the right to go after that. I guess it would be the right to go after that, as opposed to the state doesn't have the right to go after.
Yeah, for example, if in my hypothetical, the retailer taxpayer says, I forgot to collect sales tax, and the government says, we don't care, you owe it anyway. And so the retailer writes a check, but the statute then gives a cause of action effectively by the retailer back against the customer to collect the amounts that the retailer paid to the state. That's how I read the statute.
That's how I read it also.
Mr. Dunn, under 2150-109, it says, upon prosecution for a crime, the defendant may be convicted of either the crime charged or a lesser included crime, but not both. But here, this was brought up on a motion to dismiss. So we're not really, we don't have convictions yet, right?
Are you talking about 5109B or 5109D?
Oh, well.
They're two different things. The lesser included offense portion, I think, is under subsection B. We have, now there's kind of three different things there identical offenses are in E, specific generals in D, lesser included in B, and I'm forgetting. But to
D1 and 2, the statute only protects a defendant from being convicted of both crimes.
Correct. Yeah, the analogy is the same. I just wanted to be sure we're on the same page there.
But here we don't have convictions. We're just at the charging stage, right?
Correct.
So is this appeal premature?
No, it doesn't say it can't be raised before, and it simply says that you can't have that conviction. There's no restriction on when it has to happen. And frankly, there is no reason for it to go forward at any point if you can decide it then. I mean, you can file a motion to dismiss within X number of days of the preliminary hearing. That's permitted.
But you don't have a problem, do you? If you don't have two convictions, you have one conviction, you don't have a double jeopardy, double punishment, multiplicitous issue, do you?
We're not in double jeopardy. This isn't a double
Well, if
jeopardy
it talks
problem.
about convictions, how
Sure,
can we
no,
address anything less than convictions?
I understand that, and this is a way to prevent the conviction of it.
It does say when the same conduct of a defendant may establish the commission of more than one crime under the laws of the state, the defendant may be prosecuted for each of such crimes.
Sure. What,
That's
well,
what
wanna
happened
be-
here, right?
Yes, he was prosecuted for each such crimes. I don't think you can have that though in the general specific situation. I think the legislative intent behind it is clear. It talks about charging. When you look at the RECOD committee that was doing this, they were addressing a specific problem. Problem of not knowing which charge was supposed to be out there when there were things that overlapped. And I provided that legislative history. It's pretty clear that this was exactly to deal with this situation. And if you're dealing with that situation, it makes no sense that you have to wait all the way until the conviction point comes when it's something that can be decided before that.
All right, and, okay.
There's multiplicity cases. Multiplicity is a similar situation where the harm with multiplicity is a double jeopardy problem. And technically you could have both of the convictions, you just can't punish them for it, nor can you, like one of the convictions will merge and go away. But we have cases where it's been raised prior to trial or prior to a motion, I believe at the motion for judgment acquittal point, where the court has dealt with it prior to the actual conviction. And that's the thing, you can deal with it at any point as long as you get to where there is no conviction. So if you prevent that conviction before, it doesn't make sense that you have to wait till later.
I have a quick.
Which
go ahead.
subsection is the one that deals with what we're talking about here? D? Crimes differ.
Well, no, I'm talking about the legislative history. That's, you can see from that they were talking about why they created this statute. Because this statute came with the 2010 RECOD. This wasn't present under the, when everything was in the 3000s. This is all from 2010. And the legislative history on that from the committee that I provided the court with in my brief has this, and it directly is lifted from it.
And this basically was a codification of a common law rule that this court had adopted, correct?
Yes.
And in Euler, we essentially disapproved of the use of that rule, but we didn't talk about the statute. And I would like to ask a substantive question about the statute. In Euler, we said, we didn't disapprove of the concept behind it. We just said that the identical offense doctrine is the more rigorous way to analyze these issues. And my question is, doesn't this statute effectively codify the identical offense doctrine? And I wanted to ask specifically about the word only in the statute. When
No.
crimes differ only in that one, and doesn't that require a identity of elements, the word only?
No, I don't
Why
think,
not?
I don't think it does.
Well, if there are different elements, then those statutes don't fit under subsection D because they differ in more ways than only that one is general and one is specific.
First, I don't think it can mean that because we have the legislature directly address the identical offense doctrine in subsection E. And that would be surplusage. And we know If so, if we're wondering why this is there, and then we have a question, there's an ambiguity, and we go to legislative history, and legislative history tells us it's not supposed to be identical elements.
Well, the
It's something
legislature
different.
just wrote what this court had written. I mean, they just adopted the rule that this court had recited. And in Euler, we said, look, what we were really talking about is the identical offense doctrine.
Well, Euler was certainly a change from what had been years of court law on this. And we didn't have, I mean, we can look straight at Wilcox. Wilcox isn't an identity of elements case.
Do you think do you think D is ambiguous? Like, do you think the word differ only, or the phrase when crimes differ only is ambiguous?
I think also when we look at conduct, when we're dealing with conduct, when we're dealing with D, we're not just dealing with elements. The only thing they differ in. I think if you look at it's the specific thing that the legislature was dealing with here was overlapping statutes, not statutes that are contained with one another. If we look at statutes that are contained wholly within one another, then we're back in lesser included offenses in subsection D, because 5109B2, I think it is, says that's one of the ways to have a lesser included offense is when all of the elements of one offense are part of another offense. That's already taken care of. This has to be something different than that.
Off of Justice Stiegel's question, do you think then that it would be that Euler's concept of identical offenses should be slightly modified, such as to say identical element, almost identical elements between the two crimes, with one having the additional element, making it more specific?
I think if we do that, then we're back in that's lesser included offenses then.
No, it's
You
not
have
a
one
lesser
more.
included. It's the same crime. One has an additional element that makes the second crime a bit more specific.
I'm having a hard time distinguishing. Subsection B says,
Imagine all of the elements of theft.
no, I understand
one.
the concept. I'm just saying that concept's covered by the definition of a lesser included offense, where all of the elements of one are contained in another. So for instance, you have a theft
But
and
it's
then you
not-
have a theft by a parent.
But you don't have a lesser include. They're equally serious crimes. They're not lesser. One's not lesser than the other. They're equally serious crimes. One's just more specific.
I think that's just within the definition of how the legislature defined a lesser included. I don't think it necessarily means there's a lower severity level. It's just lesser as in there's fewer elements.
Got possession crimes. You've got possession of 100 grams with one crime. A less severe crime is 5 grams, for example.
Yeah, no, I understand that they're less severe. But if the definition of a lesser crime is simply one fewer element or more than one element, that's how they've defined a lesser included offense. They didn't define it by they didn't say a lesser severity level. It just said a lesser crime has one less element. Subsection B doesn't talk about severity level is not mentioned in there that I recall. And so, yeah, it seems intuitively, it would seem like you would mean one would be before we talked about amounts, simple possession of marijuana versus possession of marijuana with intent to sell. One fewer element, you didn't have that intent to sell, makes simple possession, and simple possession of marijuana first time is a class A misdemeanor or class B misdemeanor, as opposed to possession with intent in the old days was a first time. Can't have to defer to the former district court judges on that one. So yeah, it may have a lower severity level, but the real thing that matters is there's one less element. The fact that there is you don't have to have that intent to distribute. That's what makes it a lesser, is not having the intent to distribute. It sounds like you want to hear, and it intuitively makes sense that it would be a lower severity level, but that's the statute doesn't reference the severity level. It just says a lesser degree has some of the elements or all of the elements are contained in some of the elements of the other. Make sense?
Just one more follow-up. So you don't think that, drugs cocaine have the same elements? They're both drugs, but one is specifically.
Well, we don't,
What I'm saying is that you've got the same elements, intent to distribute an illegal drug, but the one can include methamphetamine or other drugs, but the other must be cocaine. More specific.
we already have that. We don't have just a general possession of drugs in Kansas. That's
I'm
not.
just using.
I mean, I mean, I can see that as a hypothetical and that poses something different. Are all of the elements there? Or is that an identical element situation? Seems like that is an identical element situation.
Are identical, except one requires.
And then the state gets to
cocaine.
pick whichever one they want in that situation, which is what E says now. And they only get one of them, but that's if it's identical elements, the state gets to choose now. They statutorily abolished the old identical offense doctrine. And now the state does have absolute prosecutorial discretion on that. I think that's a different thing. Gone way over, so I assume if there's any other questions. Thank you.
Thank you.
Good morning, may it please the court. The state appears by Jody Litvin. I guess I'll start by saying, Justice Wilson, you asked if it was an abuse of discretion for the Court of Appeals not to get to the specific versus general, and it's the state's position that it was not an abuse of discretion. We got to this point on a motion to dismiss for multiplicity that was granted by the district court, and in their ruling, they specifically said that they weren't going to address the specific versus general. Now, the state does agree that it's briefed and this court could get to it under an exception, and it's ready for this court to get to, but I don't think that they abuse their discretion in not. And just
Wasn't it
following.
raised at the district court level by the parties before the court?
Was it raised?
Was it raised?
Yeah, I believe it. I think it was.
So then if it was raised, did the district court have the discretion not to rule on it?
I think so. Sure. I mean, the district court took the multiplicity. There were several, I didn't go through all of the pleadings, but I think there were several routes that the district or that were presented in the motion to dismiss.
There were some orders made at the district court that says, well, I'm not going to rule on it, but then she did rule on it anyway. But even so, was it preserved at the trial court below such that Court of Appeals was mistaken in saying it wasn't preserved?
I don't know that the Court of Appeals said it wasn't preserved. I just think that they said, we're going to go with what the district court's ruling. I mean, the district court's ruling explicitly said, I'm not addressing specific versus general. And they were going to take that language on its face for what it's worth and, you know, just go with the multiplicity, which I think the district court explicitly ruled on and said it was multiplicitous. And the remedy was to dismiss the felony, which is incorrect.
Making that ruling in paragraph 6 of the court's order, she said, when this court considers the legislative intent of the statute by its plain language and context within the overall Kansas Retailers Sales Tax Act, it appears that the intent was to define the specific actions that constitute violations of this act and the limits of the penalties for those actions set forth in those statutes. So even though she did later say she wasn't going to do the general versus specific sentence, seems to make that doctrine part of her rationale for her. So given that that rationale, how do we avoid looking at the as we review the district court decision?
I mean, I think that, I mean, I don't know that you have to avoid it. I just don't know that it was an abuse of discretion for the Court of Appeals not to get to it. So I think that's what this court would have to find in order, I mean, but I do think it falls under an exception. So, I mean, I don't really have a hard argument either way for this court not to get to it. I think it was briefed. I think Euler threw in a little bit of I had a supplemental brief that the state really agreed with Euler, liked the decision, thought it was going to go away. And then the statute was raised. So I think that Euler kind of throws a kink into it, but I think that this court, if it wants to, can get to it in this case. I don't know that I have a strong argument as to why not to, but I don't know. The Court of Appeals abused its discretion in not getting to it and just taking what the district court said on its face. And we do agree that it's wrong under the multiplicity analysis. So that was our point in taking the appeal in the first place. And I think both parties agree that the remedy was wrong to dismiss the felony too. I don't know that I have any further presentation.
I start off with Mr. Dunn. I don't know that it matters because the state is free to pursue new theories of prosecution under the criminal code, but is this kind of a relatively new means of prosecuting a tax act to include theft? Is it something that just happened, or has this been historically done, or do you know?
I don't know the answer to that question, Your Honor. I did not ask how many times the Attorney General's office has prosecuted theft and the Sales Tax Act. I know that an answer would be from this court on those two crimes would be helpful as to whether the state wants to go to the legislature and ask to make those sort of graduated penalties like they do in felony theft. But I don't know the history on how many times we've charged it or if it's a policy. Certainly it's not in the record.
But is it an attempt to elevate a misdemeanor crime to a felony? That's what Mr. Dunn is essentially saying, is that took what the legislature purposely intended to be misdemeanor offenses, and by adding theft, you're creating a higher level of crime.
I would disagree. I think that the state can, if there's certain facts that fit more than one crime, I think the state can prosecute both crimes. I don't think that it's an intent to elevate the punishment.
And under your theory then, can you violate, with facts like this, can you violate the Tax Act without committing theft? Under your theory, is it possible?
The example I think I gave to the Court of Appeals was collecting the sales tax and then holding on to the sales tax and not actually failing to pay it. So it's like a temporary deprivation and not with the permanent intent to deprive. That's under the felony theft statute. So
that would not be a theft if you maintain possession of it beyond the time that it's due. I'm not sure why that isn't still an intent to permanently deprive, but that's your theory, is that wouldn't be a theft?
That would be the scenario, that temporary deprivation, it's still a willful failure to pay, but you're not intending to permanently deprive. And I think here it's important to know that under these facts, I believe the restaurant owner admitted to putting that money back into her business. So I mean, the intent to permanently deprive was there because, you know, it went back into.
It's just not an unusual act in businesses that are struggling.
Sure.
I understand that, but okay. I just wanted clarification. Thank you.
I want to ask a couple of follow-ups on that. In the Court of Appeals opinion, discussing this exact issue, several times when they recite the evidence that was in their view sufficient to bind over the defendant on the felony theft charge, the Court of Appeals recites that the defendant acknowledged that she owed money to the state. The defendant knew that she owed money to the state, and that therefore there's sufficient evidence to show that the Department of Revenue had an interest in the sales tax. Why that all just sounds to me like commercial debt. This is a debt. Agree or disagree with that?
I guess I would disagree with that. I don't know that the debt question was ever, I mean, the way that it was framed in the Court of Appeals was, I thought that the state had the wrong victim listed and that the Department of Revenue did not have an interest in this money. And so the state briefed it as, here's the definition of, I think, owner in 215111, any interest in property. And so our position was KDOR, definitely, they have an interest in this property.
And I think that's right. That is, I mean, the Court of Appeals just says, look, they have an interest because it's an amount that's owed. Now, that leads to my follow-up question, which is, I fall upon hard times and I stop paying my credit card bill. Am I guilty of theft? Because the credit card company has an interest in that money that is owed to them, or my mortgage, or just any commercial debt. I mean, it just strikes me that the way this has been argued by the state has dramatically expanded the ability of the state to charge individuals who owe legitimate debts with serious felonies, when this is just a commercial debt.
I guess I would disagree that it does expand it because it's under the Kansas Retailer Sales Tax Act and they have a specific application that
Well,
they.
but no, we're talking about the felony theft statute, and you just told me that the state's position is anytime there's an interest in money, that person is the owner. And that if you deprive someone of their interest in money, you've committed theft.
I guess I don't have a good answer for that question. I mean, I guess if that's the case, then I mean, I don't know that I have a good answer as to why it's not.
Let me just last follow up. Do you think that's what the legislature intended with the felony theft statute, is to criminalize the deprivation of any interest in money?
I didn't look at the legislative history of, I mean, I don't know. I don't know that I have any other presentation unless there's any further questions. We've just asked the court to affirm the Court of Appeals opinion about the multiplicity and to reverse the district court's decision to dismiss the felony theft.
As always, this is usually at my peril. Today's quick research, I was trying to find an answer to the question, Justice Rosen, about how much this has been done. In my brief, I cited the 2020 media release from the Attorney General, and in that 2020 release, they said that was the 20th prosecution. The Google also came up with a 2022 thing, January of this year, where they had prosecuted, obtained a guilty plea from another Johnson County person for the same thing. So apparently that's still going, this theory is still being used. So again, this is anecdotal. It's not in the record. I acknowledge that.
understand.
I'm just trying to answer.
It might not even matter. It was more of is this kind of a new trend? And that's kind of.
That's my point, is I believe I had never heard from it, and it appears that someone came up with this in the last couple of years. And that was really all I wanted to provide for, because it seemed, the other thing I wanted to mention was with regard to whether this was looked at below was, again, I think the language of the district court and exactly what the chief pointed out, but also to note that the remedy in this case was the general specific remedy, not the multiplicity remedy. Acknowledged in our brief that the remedy for multiplicity is that the greater stays, which is not what happened. So I think that is even further indicia with all those things, that this was actually examined below, and it is properly before the court. And perhaps that shows a mistake of law on the part of the Court of Appeals if we're further into abusing discretion as a type of abuse of discretion, that it should have been reached in the Court of Appeals. Nothing else, we would ask that the Court of Appeals be reversed and the district court's decision modified, but nevertheless affirmed for right for the wrong reason.
Last minute question. Does the prosecution implicate?
I think it quite likely does. In all fairness to the state, no one has raised this before, so I'm not quite sure that it's fair to talk about it now. But yeah, I think this is very similar in quite the same way. And I think it dovetails into why we don't have civil debts transform or commercial debts as Justice transformed into crimes in this, which is basically what the state's theory does. Try and transform debts into using the theft statute into crimes. Well, there's a whole nother rabbit hole we could go down
Okay.
on this, but I guess if that's the shortest answer I could give, hopefully that helps at home, and I hope I didn't just contribute to his own.
Does send a follow-up email that says theft in cases of fraud.
Thank you.
Thank you to both counsel for your arguments in this matter. The court will take this appeal under advisement. Now call the case of 125-500 in Ray Spencer.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I would like to reserve 2 minutes.
Brandon, thank you.
Thank you. This is an original action in attorney discipline involving the respondent Mitchell J. Spencer. Mr. Spencer was admitted to the Kansas bar in September of 2017. In April of this year, the ODA filed a formal disciplinary complaint against Mr. Spencer. After Mr. Spencer filed a timely answer and the parties had further discussion regarding the contested issues, the parties decided to forego a disciplinary hearing and submit this matter to the court pursuant to a summary submission agreement pursuant to Supreme Court Rule 223. I want to briefly discuss the facts and rule violations that the parties stipulated to. During the evening of October 7th, 2019, Mr. Spencer was playing golf with his mother at a club in Wellington, Kansas around 7 p.m. After they were finished golfing. Mr. Spencer drove the golf cart he had rented from the club through the club's parking lot in order to return it. As Mr. Spencer was driving the cart through the parking lot, he was distracted because he was looking down at his cell phone. This caused Mr. Spencer to drive the golf cart into the back of a truck that was parked in the lot. The collision caused damage to both the golf cart and the rear bumper of the pickup truck. After dislodging the golf cart from the truck, Mr. Spencer proceeded to drive the golf cart to where the club stored golf carts. He then left the golf club with his mother, and mother was driving the car. At the time that he had left the club, Mr. Spencer, he knew at that time that the collision had caused damage to both the truck and the golf cart. Despite knowing this, he didn't take any action at that time to notify anyone about the accident or leave his contact information so the golf club or the owner of the truck could contact him. Mr. Spencer didn't timely notify either the owner of the truck or the golf club regarding the accident the day after. 3 days after the accident, the owner of the truck saw Mr. Spencer at the club and approached him to discuss the matter. 9 days after the accident, after the golf club had already reported the matter to the Wellington Police Department, Mr. Spencer sent a Facebook message to the manager of the golf club asking about damage that had been done to the golf cart. On October 23rd, 2019, Wellington Police Chief Tracy Heath conducted a formal interview of Mr. Spencer regarding the accident. During that interview, Mr. Chief Heath asked him about whether he knew that there had been any damage caused to the accident. And during that interview, Mr. Spencer said that he was not aware of any damage that had been caused by the collision. That was a false statement. Ultimately, Mr. Spencer received a citation for violating KSA 8-1605, duty of driver upon damaging unattended vehicle or other property, which is classified as a Class C misdemeanor. The matter was originally filed in the Wellington Municipal Court by the city prosecutor, but the city prosecutor later dismissed the matter and referred it to the Attorney General's office for prosecution. Ultimately, in June of 2020, the AG's office instituted a traffic case against the respondent in Sumner County District Court. Prior to that case being filed in district court, Mr. Spencer had paid for the damages his accident had caused to both the golf cart and to the pickup truck. In July of 2020, attorney Michael Brown forwarded a copy of the Sumner County complaint to the ODA. The matter was docketed for investigation, and Mr. Spencer was asked to provide a written response. In his written response, Mr. Spencer failed to acknowledge the full extent of the damage the collision had caused to the golf cart and the truck, and gave the impression that he had timely notified both the truck owner and the golf club manager about his involvement in the collision. Ultimately, Mr. Spencer retained counsel and submitted a supplemental response to the complaint, acknowledging his failure to timely take actions to notify both the truck owner and the golf club about the collision.
Counsel, I'm gonna interrupt you there and just ask my, not really a legal question, I guess, but help me understand why this isn't all essentially a silly exercise over a busted taillight, which everyone who actually was involved basically resolved, like using common sense and outside the confines of the Supreme Court courtroom.
I asked myself that same thing when we were prosecuting this case. And my only response is that initial accident happened. If Mr. Spencer would have just notified the club and the truck owner at that time, or even the day after, or even 2 days after, and made the offer to pay for the damages, this matter would not even be in front of us.
But
right now.
that ultimately happened. I guess this,
It
it
ultimately-
strikes me that this case could be a poster child for what often flies under the heading of complaints that we live in an over litigated society.
I think what elevated this to being in front of the disciplinary administrator's office was first we received a complaint, and then once
Sure.
we investigated it.
I'm not criticizing your office. I'm just, boy, this just like seems like a snowball that should not have been, shouldn't.
Well, help me with that, because I had the same initial reaction to this. I read the submission here, the joint, as being elevating the incident because of what the office less than forthright responses to the initial investigation, ethics investigation complaint. Am I reading that wrong? In other words, we not only have this incident, which is say what you want about it, but then it's aggravated by what you saw as not being honest in responding to your inquiries. Is that right?
That would be correct. I mean, going back to the incident, when I think what elevated this was the October 23rd, 2019 statements to the police chief denying that I didn't know at the time of the collision that any damage had been done. And then when the police chief showed him surveillance videos of the collision, I think it became quite evident to Mr. Spencer that that was not a great position to take. And so that, in addition to that, the fact that this occurred in Wellington, the county seat of Sumner County at the time, Mr. Spencer was an assistant county attorney there, was also a city attorney in another municipality located in Sumner County. I thought in my mind elevated this to resulting in a disciplinary complaint. Plus, I could tell you that the review committee considered prior to filing a formal complaint, Mr. Spencer, through his attorney, applied for diversion. The review committee reviewed that application, determined that because of the dishonest conduct that occurred in this case, that Mr. Spencer wasn't eligible for diversion under the diversion rule, which would be Rule 212B, saying that if a respondent engaged in dishonest conduct, they're not eligible for diversion. So those are the reasons why we resulted in a formal complaint. But again, because of, yes, it was a golf cart that ran into the back of the truck. That's why ultimately I think the parties agreed that I need to go to a disciplinary hearing on this, that this could be resolved through a summary submission agreement.
Let me follow up with one other thing. So the probation plan, the review of his practice and the agreement regulate the intake of clients and kind of bring down the pressure of his private practice is the way I'm reading. Appears to me that that probation plan is the result of what was submitted from the psychologist respondents present state, if you will. And so therefore, some additional supervisory thing, because, you know, I don't know, honestly, you look at this event and it doesn't cry out for practice supervision. So I'm just saying, the way I'm reading this again is it appears that as the parties work themselves out, it was a good idea to have additional supervision practice. Is that right?
That is correct. And I think, be honest, Mr. Spencer's attorney approached me, asked about a possibility of doing a public censure, of us agreeing to a public censure. I was in agreement with that because, again, at the time of this accident with him, Mr. Spencer being an assistant county attorney, also being a city prosecutor, I thought that this warranted something more than a public censure. But I believed that Mr. Spencer should be able to continue practicing law and not have to suffer the consequences of the suspension. That's why I was in agreement with probation. And so Mr. Rapp, Mr. Spencer's counsel, put forward the probation plan. I added a couple of additional conditions, primarily being the additional ethics CLE and the letters of apology to the 3 individuals. And they were in agreement with that. And that's why that's the probation plan that you have before you today.
Was there, I can't remember exactly, but was there at some point private communication or something that that the respondent felt like that it was an act of retaliation, act of retaliation by the complainant?
Yes, that could be found in Mr. Spencer's response to the complaint. Michael Brown, who is an attorney, I believe he practices in Derby. And this is outside of the record, but
But is there,
I think
is
Mr.
that response
There is
letter
his
in the
response
record?
saying that it was retaliation because Mr. Spencer had filed a disciplinary complaint against Mr. Brown. And so Mr. Spencer felt that this forwarding of this complaint from Sumner County to our office was in retaliation for that prior discipline filed against him. Yeah, that was, at least that's what Mr. Spencer put forward as Mr. Brown's motivation for forwarding that complaint to our office.
In the first couple of years that practice, he did file multiple ethics complaints against me.
Again, this would be only from Mr. Spencer's response, but I'm only familiar with the disciplinary complaint that he would have filed against Mr. Brown. And then the city prosecutor in Wellington, Sean DeJarnett, I believe Spencer may have filed a actual judicial complaint against him because Mr. DeJarnett, I believe, acts as a municipal judge in one of the municipalities around the Wichita area.
Let me go back, if I could, to the alleged dishonesty here. As I read the summary submission, there was a conversation between the respondent and the truck owner, at which point essentially it was trying to read between the lines here, it was, hey, sorry I hit your truck. Yeah, no worry, everything's fine. And then later, the alleged dishonesty comes from the interview with the police. I guess applying a technical definition of damage is where you get to dishonesty, but in the context of just regular human life, right? Human conversation. Oh, I talked to the owner, he said everything's fine. cop asks me what's going on. No, there wasn't really any damage. Oh, well, we have this video surveillance of you. It just strikes me as being. I mean, I recognize the technical nature of the allegations here, but is this form over substance? I mean, the substance of this, I'm struggling with, obviously, for my question.
Right. I would also refer you to the damage that was done to the golf cart, which they provided an estimate to the police of being $700. So just the damage to the truck wasn't the only thing that was a result of the collision. There was damage done to the golf cart. There was damage done to the truck.
Is there any evidence in the record that would demonstrate that
I believe
he knew about damage to the golf cart?
Stipulated to knowing that there was damage done to both the truck and to the golf cart. So it's not just the damage to truck. I mean, it was a 1995 Silverado. The owner of the truck got an estimate saying that the piece of rear bumper that was broken off, if you wanted to just replace that, was $29 to buy that part, but it was also, I believe they got an estimate of $90 labor to literally take the old bumper off and put that on. And so the damage wasn't minimal is what I guess I would respond to. In conclusion, I would just ask this court to accept the recommendation that the parties have jointly come together with as imposing a 90-day suspension, stay that suspension, and place Mr. Spencer on probation for 1 year pursuant to the terms of the probation plan the parties have submitted to you. Unless there's any other further questions. I say I have no further time. I'll address you during rebuttal.
Thank you.
Thank you.
May it please the court. Chief Justice Lukert, members of the court, my name is John Rapp. I practice in Wichita, Kansas at Hinkle Law Firm. I'm here today representing Mitchell Spencer. Mr. Spencer does wish to address this court if you all will listen to him. I'm sure there may be some questions the court may have and want to ask of him. Also present today, many of you know him, is Mitchell's supervising attorney, Alan Roop, a member of Lewis, Brisbois, Bisgard, and Smith. He works out of the Wichita and Kansas City offices for that firm and is proposed to be Mitchell's supervising attorney. Focus of today's hearing is the appropriate sanctions to be imposed against Mr. Spencer for the misconduct he has admitted. The parties, both the disciplinary administrator and the respondent, have submitted a summary submission agreement, as was discussed in Mr. Vogelsberg's address. Both parties are recommending a 90-day suspension, with that suspension being stayed and him being placed on 1 year of probation. It's often said that the primary purpose of the disciplinary process is to protect the public from unscrupulous lawyers. Mitchell Spencer is certainly not an unscrupulous lawyer. You heard the facts that gave rise to this case, and it was just a number of missteps after the incident at the golf course. Mr. Spencer is, in fact, a very gifted, hardworking, honest lawyer and a very good man. He is active in his local bar association community and well respected by his peers. You know that Mr. Spencer has fully cooperated with the disciplinary administrator's office since the advent of this matter. He stipulated to the underlying facts and to the resulting violations of the Kansas rules of professional conduct. He voluntarily entered into this summary submission agreement, admitting his misconduct. We understand that the picture painted by the formal complaint, the answer and stipulations, is not a pretty one, but it's not an accurate depiction of who Mr. Spencer is as a lawyer or as a person. Mr. Spencer was an extremely young lawyer at the time this event occurred, having graduated in 2017, this incident occurring in 2019. He understands the serious nature of his misconduct and that he is a lawyer all of the time.
Counsel, I'm gonna just interrupt you.
Yes, sir.
And I completely understand where you're coming from, and you entered summary stipulation or a summary submission that has stipulations. I understand all that, and I appreciate your recitation of you're essentially stuck with describing the serious nature of this conduct. But I want to push back a little bit on that. Is this, I'm just reading paragraph 31 of the summary submission agreement, which is your client's response to the ethics complaint. And honestly, it just looks like that looks pretty good to me. That response, I'll just be straightforward. How did we get from, or from your perspective, I guess, do you think that the respondent's response which is recited in paragraph 31, that just all wrong? And obviously it is, given the summary submission agreement, but.
I wouldn't suggest that it's blatantly wrong, but I would suggest that it's tailored to tell a story. And I've been advised, and there's some other facts that maybe aren't in the summary submission agreement, but inclusive of Mr. Saffel not wanting any compensation for the damage to the truck, whether he said it was fine or not, seemed to be a bit controverted. But whether or not he said it was fine and didn't want any compensation, he certainly accepted it when we got to that point. I too had problems analyzing this case from standpoint of the golf cart, because I got to see the wreck. I mean, it's on a video, and golf cart hits the truck pretty hard. And so under Rule 8.4, I had problems with, was there a commission of an obstruction of justice with Chief Heath? Were there other crimes that weren't charged that would come to light in front of a hearing panel? And so I guess, that was major concerns that I had. I do not do anything unethical regarding the golf cart incident. I think in a broad sense, maybe that is true, but under 8.4, telling falsehoods or half truths, even out in a public sense, could be considered a violation of that rule.
Well, so that gets just to this is my bigger question about how our ethics rules ought to be applied. There might be facts that aren't in paragraph 31 that would color or change the way it appears to me, but just looking at that, and frankly, the whole summary submission, it just looks like the way this was initially handled is just the way mature, ordinary adults handle things that happen. And that now we've elevated it into, criminal charges and disciplinary cases, and just wondering if that's is that what we want from our ethics rules?
Certainly, as respondents counsel, we took every effort, starting with censure, informal admonishment, diversion. All of those were denied, and what I was advised was the Office of Disciplinary Administrator was holding him to a standard, and part of that was because he was the second in command in Sumner County as assistant county attorney. And he was held to a higher standard because of that, to be honest and forthright during this investigation.
What's wrong with that? I mean, he's a prosecutor, he's assistant county attorney. He understands the implications of falsehoods to law enforcement when you're being investigated. And that's what he did. I guess that, to me, and I agree with my colleagues who've spoken about this, you start reading this, it's like, what are we doing? But just that alone seems to me to trigger a pretty big concern here.
And that was a concern that we had as attorneys, what was going to happen before the hearing panel when that was discussed and those facts came out. What sort of recommendation was going to be made by them at that point?
And he did, it is true, right? I mean, the record shows that he falsely stated to the police chief that I wasn't aware that my accident caused any damage to the golf cart, but he really was aware, right?
Yes.
Thank you.
Tell me about the practice supervision plan. That, I mean, honestly, again, looking at these facts, I can see why we've got a disciplinary thing. I don't know that it cries out for practice supervision until you see that report from the doctor. And I understood Mr. Vogelberg to say that you suggested the supervision. But just tell me about the plan, regardless of whether I'm right or wrong about that.
Well, certainly at face value, it seems like there may be too much supervision or be unnecessary supervision. Mr. Spencer left the county attorney position shortly after, it was in the fall of 2020. And has been an attorney at Louis Brisbois, where they have a number of mentors and a system. And Mr. Roop runs a tight ship over at that office, and Mr. Spencer works directly under him for the most part. And they oversee a lot of his work anyway. I think the practice plan is a good plan because in trying to understand how we got here, Mr. Spencer underwent a psychological evaluation with Dr. Lance Parker, and Dr. Parker opined that anxiety and stress cause Mitch holds himself to an extremely high regard and holds himself to a high, he expects a lot of himself. And when he fails, he has a hard time admitting that he failed. Or when he does something wrong, he has a hard time admitting he did something wrong. The idea of having a practice plan with a supervisor may take some of that pressure off of Mr. Spencer to feel like he can't admit when he's wrong. He can go to his supervisor, in this case, Mr. Rupert, one of the other 1,500 attorneys in his new firm, and express to them that I'm having trouble with this issue. How should I handle this? Hey, I had an accident with a golf cart, hit a truck. What should I do with that? You know, somebody else being there to talk to Mr. Spencer about anything, even outside of his practice, would be helpful. We all need mentors or needed mentors at one time in our life. I've been blessed with many and would not hesitate to call them if I was in a situation to say, hey, let's get another set of eyes to look at this scenario and figure out how I should have handled it better or different, or just have some advice. That was the reason for the probation plan, was to maybe take some of the stress off Mr. Spencer that he feels to try to be perfect. And that brings up an interesting point, because Mr. Spencer is, while he's being held to a higher regard, higher level of duty because of his fact he was in the county attorney's office, he left there over 2 years ago.
How does that work? Do we have two sets of rules? One for prosecutors, and I mean, we have a specific ethics rule that covers prosecutors in the execution of their official duties. But beyond that, how does this work where we create a higher standard based on what job you have?
Well, I would submit, and I can't cite case law at this time, sir, but it seems to me that we've read over the years that prosecutors in dealing with law enforcement and whatnot, their duty to be honest and forthcoming may be higher than a normal citizen.
There is a specific rule,
yes, sir,
that governs prosecutors, but that rule is not implicated in this case. Is it?
I don't have a good answer for that, sir. Mr. Spencer's in a completely different place in his life. A lot of changes have happened in the last 2 years. He works at a different firm with a number of mentors. He got into a bit of a toxic relationship with some of the other lawyers in the Wellington-Sumner County area. I can tell you, I know that from witnessing it. I practiced down there at those times, and the defense bar and the prosecution teams were not getting along very well. And you've heard some of that today with ethics complaints being filed by folks against both sides going at each other. He's out of that. He lives in Wichita now. He's working at Louis Brisbois, totally different area of law, number of mentors. I've stated that. I would submit that Mitchell is certainly a lawyer with a bright future and one that needs to put this mistake behind him. He's an asset to the community. He's an asset to his clients. He's an asset to his firm, and I'm proud to have him as a colleague. Respondent requests that he be suspended for a period of 90 days with that suspension stayed and be placed on probation for 1 year. Or have any other questions of me? Mr. Spencer would like to address the court.
Thank you. I apologize for being here today. I take full responsibility for my actions. And does anybody have any questions for me? All right, thank you.
Against my better judgment, I guess I'll try to address some of Justice Deagle's concerns. Where the heightened standard, the higher standard that we treat prosecutors at, I believe comes from this court's case law. I would cite In re Holste, 302 Can 880, 2015, long string cite in that opinion where the court acknowledges that they hold prosecutors to a higher standard. And so, not explicitly stated in our rules of professional conduct, but
Well, isn't there a notice? I mean, aren't there significant problems? I'll take you at your word that that's what our case law says. Isn't there a problem with that?
I think that
At a minimum, like a notice problem. Shouldn't we have a rule that says that?
I guess that would be up to this court to decide whether there should be a rule, but I mean, we've had a long line of cases talking about because of the immense power the prosecutors hold.
Well, typically double standards in the law are frowned upon. And how is this anything other than a double standard?
I'd say if another attorney under these facts, if Mr. Spencer was not a prosecutor at the time, and if we had the evidence, including the conversation they had with the police chief, where he subsequently later admits that he knew at the time of the collision that the collision had caused damage, and he admits that when he told police chief that he was not aware of that was a falsehood, that would be an 8.4C violation.
And they would be.
We've had attorneys, non-prosecutor attorneys though, that have gotten, tagged with misleading law enforcement officers in the course of an investigation into other conduct. I mean, that gets brought up. I can't specify the cases, but I can recall them in several, traffic accidents and DUIs and that sort of thing, and, sort of misleading responses. And we talk about it being officers of the court, all attorneys. So this part doesn't strike me as getting you because you're a prosecutor. I mean, aggravating to have that, but we're all officers of the court, and we're not supposed to lie or mislead law enforcement.
I agree with that. In fact, one case, for example, would be In re Mintz, 298 Can 897.
How do you spell that one?
It'd be MINTZ. Citations 298 Can 897. That conduct, that result was an 8.4C, 8.4D violations. The conduct in that case was more serious than what Mr. Spencer was in agreement with. I mean, that was that the lawyer in that case was trying to cover up his involvement with going out the night before with his girlfriend, who was a recovering alcoholic. And so obviously much more serious, but that's an example of a lawyer, non-prosecutor, misleading police, being held to a violation of 8.4C.
I just want to clarify that in this case, it seems very clear to me that everyone has conceded that the disciplinary administrator applied a higher standard to this respondent. And you just began your argument by saying that 5 minutes ago.
I would say the recommended sanction that I was recommending, that I told Mr. Rapp that I would agree to, would be probation. And that was on the basis of Spencer being a prosecutor at the time.
Okay, thank you.
As far as the rule violations
Right.
go, that didn't play a part. Him being a prosecutor at the time didn't make me determine like, oh, this was an 8.4C violation.
Thank you.
So I'm sorry if I.
No, you've been clear. I just wanted to clarify as further. Thank you.
And then I guess, well, I'll address you cited paragraph 31 of being the summary submission agreement, thinking that was an appropriate response. I guess I would politely push back with saying that when he claimed that it only cost $20 to fix the truck, when he made that response, he had already paid the estimate that the owner of the truck had received, which was $100. And so wasn't quite accurate. But also in that response failed to acknowledge that he also paid a $700 estimate for the damage done to the golf cart. And so
Well,
that's
I thought he said he'd already made it right, basically.
at the time. So that statement comes from his response, which he provided to the ODA August of 2020. By May of 2020, he had paid both the estimate to the truck owner for the damages done to the truck and to the golf cart. But what I'm saying is, in his response, did not even acknowledge any of the damage that had been done to the golf cart.
Okay, when,
No one was at the golf course. Was at the golf course who?
I don't know. He stipulated that he was not aware of anyone being at the golf course as an explanation of why he didn't go out at that time and search out anyone at the golf course to report the accident to.
and in fact, the only person at the course was off in a outbuilding somewhere, not in the clubhouse, for example.
I
Correct.
believe he was at the golf cart shed where Mr. Spencer was returning the golf cart to, or at least that general area where the club kept the carts.
Does the fact that the respondent reached out to the manager of the golf course and asked, did you have any damage to the golf cart the other day? And never got a response, does that affect the later interview with the law enforcement officer?
I don't know.
I mean, why wouldn't it be reasonable for, let's just say, a person, not a lawyer, who had this incident, be like, I reached out, I didn't hear back.
Yeah.
So I don't think there's any damage when the cop calls you.
Say that we've submitted stipulated facts and Mr. Spencer has stipulated to, when he told the chief, I wasn't aware that any damage had occurred, that was not true. I don't.
Thank you.
Thank you.
Thank you to all of you for your arguments today. At this point, the court will be in recess for 15 minutes. We will resume at 10:40.
All rise. Honorable Justices of the Supreme Court. Hear ye, hear. From recess. Now sitting.
Please be seated. I'll now call 125-499 in Ray McVey.
May it please the court, Gail Larkin, Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator. This is an original action in discipline filed by the Office of the Disciplinary Administrator against the respondent Jeffrey Lee McVey of Great Bend, an attorney admitted to the practice of law in Kansas in 1993. On March 18th of this year, our office filed a formal complaint against the respondent alleging violations of the Kansas Rules of Professional Conduct and the rules relating to the discipline of attorneys. The respondent timely answered on April 6th. Thereafter, on May 26th, we filed an amended formal complaint, and again, he timely answered on June 14th. In the respondent's answers, he stipulated that he violated KRPC 1.15, which is the safekeeping of property rule. At the hearing on the amended formal complaint, he appeared personally and with counsel, and that hearing was conducted on June 28th, 2022. Following that hearing, the hearing panel concluded that the respondent violated KRPC 1.15, subsections A, B, and D, that the respondent violated KRPC 8.4C, which is the rule that prohibits or that defines professional misconduct involving dishonesty, misrepresentation, deceit, and fraud. And the hearing panel concluded that the respondent violated Rule 210, which is one of our cooperation rules. At the hearing, I argued and the hearing panel agreed that the appropriate discipline in this case is a one-year suspension with the requirement of a 232 hearing following that period of suspension. Because neither party took exceptions to the final hearing report, under Rule 228G, the hearing panel's findings of fact and conclusions of law are deemed admitted. Currently, this case is uncontested, and the only issue before the court today is the appropriate discipline to impose. My recommendation today remains the same as it did at the time of the hearing, and that's a one-year suspension with the requirement of a reinstatement hearing. Give some background facts. In 1993, when the respondent first became a lawyer, he went to work for Brock McPherson in Great Bend. He remained employed with Mr. McPherson until May 29th, 2020. The disciplinary case arises from the respondent's representation of two clients during that practice. The two clients are BG and MK. BG's case, he retained the respondent to represent him in a family law case in March 2020. He paid a $1,000 advance fee in cash, and that fee was to be earned at a rate of $200 per hour. The time it was paid, it was not earned. Rather than see that the unearned fee was deposited into the attorney trust account, the respondent placed the cash into his desk drawer. He had other cash in that desk drawer, and the cash was commingled. The respondent testified that he deposited that account or that cash into an account. He was not sure which account he deposited it to, but he admitted that he used that money for his own personal expenses. Ultimately, the respondent converted the fee paid by BG to his own use to pay those expenses. In that regard, the respondent stipulated that he violated 1.15. I do want to clarify that the respondent provided representation to BG. He didn't complete the representation before his employment with Mr. McPherson ended, but he did provide some representation. And at the hearing, Mr. McVey testified that he believed he had earned the entire $1,000 fee. The fee should have gone to the firm, not to the respondent. In this case, regarding BG, the respondent's conduct violated both KRPC 1.15A and D. Violated subsection A by failing to deposit the unearned fee into the trust account, and violated subsection D when he failed to preserve the identity of the funds by commingling BG's cash with other cash that was the respondent's. In addition, under these facts, the respondent violated KRPC 8.4C because he converted the attorney fee to his own use and used that fee to pay personal expenses. Later, when Mr. McPherson learned that the fee was not properly deposited into the attorney's or into the firm's trust account, he confronted the respondent. Respondent told Mr. McPherson that he forgot to deposit the money. As a result of this, it appears from the complaint that Mr. McPherson filed that he terminated the respondent's representation or employment at that time. Moving on to the second case, and in that case, the client's name is MK, and she's an elderly woman who owned quite a bit of property. And the respondent, and back in about 2010, the respondent began managing her rental properties. She had several rental properties, and as a rental property manager, he would list the properties, locate tenants, collect rent, address minor repairs, and disperse the rental income to MK on a monthly basis. For that, he received 10% of the rent collected. He operated this rental business or this rental management business out of the law firm. He used the law firm's letterhead and facilities to do that. Tenants would come in and pay in the office, and he would provide them with a separate receipt book or receipts from a separate book. In 2012, the respondent drafted a buy-sell agreement on behalf of MK for a contract for deed situation involving property located in Great Bend at 500 Odell. RA and GA were the purchasers of that property through that agreement. After drafting that agreement, the respondent agreed to serve as an escrow agent on that property, and he would receive the payments, he would pay the taxes and the insurance, and then he would remit those the balance to MK on a monthly basis when he provided the rental balance. In 2015, MK sold her properties, and after she sold her properties, the respondent continued to serve as an escrow agent for MK regarding the Odell property. That was the only property that he had involved with after that time. While MK expected to receive those payments on a monthly basis, the respondent often didn't provide those for 5 or 6 months at a time. In 2020, RA came to the office, to the law office, and paid her payment on her home every month. And her standard practice was to pay cash on the last business day of the month. And she paid that way in January, February, March, and April. Respondent did not inform MK that he received those funds, nor did he remit the funds to MK as they were received. After the respondent was terminated from his employment in May of 2020, the respondent sent a letter to RA and GA informing them that he was no longer officing at the McPherson office. He provided them with a new address where they could deliver payments. According to the respondent, he sent a copy of that letter to MK. According to MK, she did not receive it. Now, after the respondent was terminated, MK went to great lengths to try to recover the payments that had been made for January through April. She called his phone, his home phone, and was told that he would be coming to the phone would be set down, and then after a period of time, the phone was hung up. She stopped by his house and saw that cars were there, but nobody answered the door. She called the respondent's mother, as they were acquaintances, and she also stopped by the mother's house. Finally, according to her interview, when she was interviewed by the KBI, she also sent a registered letter to the respondent. Respondent indicated that he never received that letter. It wasn't until August 6, 2020 that the respondent provided MK with the money he was holding on her behalf. He provided her with a cashier's check in the amount of $1,700. Now, the respondent did not have an accounting to establish how much money he owed MK. He paid MK $1,700 because that's what she asked for. Back in 2007, when the respondent first began managing rental properties, he managed them for the law office, for his mom, as well as MK. Over time, he managed them for those 3 entities. He set up an account with Community Bank located in Great Bend, and the idea was the account would be used solely and exclusively for the rental property business. And in fact, in his answer, in his amended answer, that's what he said. It was set up for the sole purpose. But it wasn't a business account, it was a personal account, and it wasn't in a business name, it was in his wife's name and his name. In 2020, that account, and you can see from Exhibit 6 and 7, some of the bank statements that are there, that account rarely had sufficient money to cover the amounts that should have been held solely on MK's behalf. For example, on March 26, 2020, the account should have had at least the January and February payments of that year, totaling $900. The account balance was only $3.90. During the disciplinary hearing, the respondent admitted that he did not use the account for the sole purpose of the rental business. He testified that he used the money that he was holding in escrow to pay his own personal expenses. He stipulated that he violated 1.15 when serving as an escrow agent for his client MK. In this regard, the respondent violated KRPC 1.15 in 3 ways. First, he failed to deposit the funds in a separate account as required by subsection A. He failed to notify MK that he received funds, and he failed to properly deliver those funds. Then that's in violation of subsection B. And in violation of subsection D, he failed to preserve the identity of MK's funds. He testified that he placed the cash paid by RA in his desk drawer with other cash, again, commingling his client's funds with his property. In addition to 1.15, the respondent also violated KRPC 8.4C in this regard. He converted MK's property to his own personal use by paying his personal expenses. About a month after Mr. McPherson terminated the respondent's employment, he filed a disciplinary complaint against the respondent. And during the investigation of that complaint, the investigator asked the respondent for certain documents. He asked for complete bank records. He asked for an accounting of the money he held on behalf of MK. And he also asked for a copy of the agreement that established their agreement regarding escrow services. The respondent did not provide those documents as requested by the investigator. Mr. Hazlitt also asked for the accounting and the agreement. Again, he did not provide those in violation of Rule 210.
I have a couple questions about the 210
Certainly.
rule violation. The rule says the attorney must timely respond to a request for information. It strikes me that your allegation and the findings of the panel are that the respondent did not provide documents.
Correct.
Does that fit with Rule 210?
This is how you define respond. To me, when the
And information as well. Sorry. to
absolutely.
interrupt.
I think that the rule would have no meaning if we were to just say, if the response were no, I'm not going to provide you those. That's not really responsive to the request. It's not providing what's necessary to kind of complete the disciplinary investigation.
Doesn't your office have subpoena power?
We do.
And so what the way this rule is being interpreted in this case strikes me as essentially making the respondent, it's a shortcut. You don't have to issue subpoenas for documents you want. You can just hold Rule 210 over a respondent and say, if you don't give us all the documents we want, fail to cooperate.
Well, I think that we have to kind of back up one step, and the respondent was required to maintain these documents under Rule 1.15, which talks about maintaining full trust account records. The money should have gone into a trust account. He should have had trust account records for 5 years. So these should have been things that he had in his possession all along. So we weren't asking anything more for him than what he should have been doing in order to comply with Rule 1.15.
What if the response from a respondent to this kind of request is, I will comply with any lawfully issued subpoena? Would that satisfy Rule 210?
So you're saying we should have subpoenaed the records from the respondent rather than from the bank?
Just trying to define the duty under Rule 210. I think that is important if these are going to be rule violations in these cases, that at least as a matter of notice to the bar, what does this duty to respond really entail? Because you're right, it could be read narrowly or broadly. And the narrow reading of it would be that you just simply have to timely respond. And a response could be no, like, I'm not going to give you the documents. That could be a response.
I think that certainly would not be in the spirit of the rule. The spirit of the rule is to provide information so that the disciplinary investigation can proceed orderly. I did a little research on kind of what cooperation is necessary under the rule. And I came across three cases that I think are kind of interesting and kind of helpful in this regard. The first one is kind of the one that we used to always refer to as the cooperation case, and that's Saviano. It's a 1983 case. It's found at 234 Can 268. And it talks about what the, and it's based upon the old Rule 207, which is very similar to the current Rule 210. But it talks about the plain import of this rule is to impose a duty of cooperation regardless of the nature or subject of the complaint. So it's not necessarily, the cooperation is not limited to just response. It's talking about aiding in the investigation. The language is simple, straight, the court went on to say that language is simple, straightforward, and unambiguous. It imposes the duty of cooperation on every lawyer under this court's jurisdiction, with one exception, and that's the right against self-incrimination. So, my position is that if we make a request and it doesn't, and it furthers the investigation, then it's something that the respondent needs to comply with or be found in violation of Rule 210 as well as 8.1. Another case that I thought was kind of helpful also was I think it's Dudan. It's 292 Can 83. It's a 2011 case. In that case, it talked about rule violations by a retained attorney may be imputed on a lawyer. So that really is going beyond what it was going beyond what I thought the rule meant at the time to be, really, but it basically is saying, even if the retained lawyer doesn't cooperate, that can be imputed to the lawyer. And finally, in the Corin case, it's a 286 Can 421. In that case, the respondent failed to provide bank records as requested and claimed that computer problems prevented him from complying with the request. In that case, the rule violation was found. Finally, the last little part of Saviano that I want to kind of point out is it talks about, why lawyers are required to cooperate. And it says, the court stated, our procedures ensure that the public, that their grievances, real or imagined, against an attorney will be investigated and resolved promptly and impartially. No procedure can be designed to protect attorneys from groundless complaints. The ability of the disciplinary administrator to investigate, interview, and evaluate without restriction is the best assurance for attorneys that groundless complaints will be terminated as quickly and as efficiently as humanly possible. So I think that those cases kind of taken together really kind of establish why the cooperation rule is important. And I think that clearly was violated in this case.
Do you have to docket a case before you can issue a subpoena?
No, I think that we have a brand new subpoena rule, and I will look at that and might come back up on my 3 minutes. I'll let you know the answer to that question. Because we specifically talk about initial complaints and reports, and we talk about docketed complaints in the rules. And I'm not sure how that one is phrased, but I will double check that just in a moment. I want to touch briefly, the probation plan is not substantial. It's not detailed. It was not put into place, and it cannot correct the misconduct in this case because the misconduct involved dishonest conduct. Under Stockwell, the court is generally reluctant to grant probation when the misconduct involves fraud or dishonesty because supervision, even the most diligent, cannot often effectively guard against dishonest acts. And in conclusion, I think that the standard that's appropriate is 4.12, and it provides suspension is generally appropriate when a lawyer knows or should know that he's dealing improperly with client property.
I have one real practical question. You've asked for a reinstatement hearing. In our recent disciplinary opinions that have come out over the last few months, a couple of them followed reinstatement hearings. And if you just look at the dates that are recited, I think, at least in those cases, we were running somewhere around 3 years between the petition for reinstatement and the reinstatement hearing. Can you shed any light on where we might be at now in terms of that delay?
Certainly, I think that in one case in particular, there was a long investigation and there was some delay attributable to the actual petitioner in that case for not getting information back during the course of the investigation. But I think typically once an investigation, once the court determines sufficient time has elapsed to reconsider the prior order of discipline, from that point to through the investigation to the hearing and back before the court, I think it's on average is 9 months. And I think that that question's been asked a lot over the years. And I studied that question, but I haven't had the opportunity to be before the court until today. But I actually studied that, and I think 9 months is pretty typical. And when in my previous job, and I would advise hearing panels, that's what I would tell them. And then of course it can be shorter than that, obviously, but it can be longer than that depending upon how much cooperation is involved with the petitioner. And I do think in the last case, COVID certainly had a big impact on that as well. And if you're interested in knowing why I want the reinstatement hearing, I'm happy to provide that. But if there's no further questions, I will sit down at this time.
May it please the court. My purpose here today on behalf of Mr. McVey is to ask that the court use something that seems to be ignored in some places in the law anymore, and that is common sense. We're not, from the very get-go, Mr. McVey, along with my office, not one time did he ever deny that he violated Rule 1.15. The time in question is important since he was summarily terminated by Brock McPherson, who he worked for all those years. And that would have been the last part of May or thereabouts. And until Mrs. Keenan, who's the lady that had the house that was being sold on contract or whatever, she wanted a final payment. And he eventually paid her. But it would only be from approximately June until August when the payment was made. And he didn't deny that when he left McPherson's firm, where he hadn't been dealing with a trust account as far as the deposits that were made, et cetera, he thought it would be easier just to use the checking account that he had for his family, well, his wife, and handle it like you would if you were handling a management account for rentals. Now, he knows now that you shouldn't have done that, or he shouldn't have done that. No question. No question. But, and I hate to make this personal, and if it stays that way, I can't help it. From the get-go, the disciplinary administrator's office has said nothing but suspension, period. And it just doesn't fit in this case. We offered to take, well, we tried everything. You take diversion. They said no. And we said, would give us published censure. No. Suspension. Now, suspension is one notch below disbarment. And this just doesn't fall into that category, folks. From all the things that you've heard over the years on disciplinary matters, if what Mr. McVey is accused of doing, if that's going to bring about this type of a suspension, then we're going to have a lot of cases here, it looks like, because that's just not workable. And I hate to, I've lost enough cases over my career that I guess one shouldn't admit vulnerability, should you? But anyway, at the same time that they're arguing for suspension with Mr. McVey, we recently had a decision from Mr. Pistotnik, who pled guilty to 3 misdemeanors that were reduced down in federal court. And his track record in front of the Board of Discipline in this court dates back to November 8, 1985, where he received informal admonition for improper conduct to people of the parties in a domestic matter. In August of 91, he was informally admonished for violating a 1.15. In December of 93, he received a 1-year suspension in the case of Pistotnik, or N. Ray Pistotnik, 254 Kansas 294, for diligence, communication, etc. April 7 of 94, he received informal admonition again for 1.15 violation. And in May of 94, he received informal admonition for another 1.15 violation. And he was given a 1-year suspended sentence approved by the disciplinary administrator's office. And what happened to Mr. McVey, if this, it doesn't come close. And more recently, I would point out, as you probably know or remember, and I don't have all the facts on this case because it involves a good friend of mine who I practiced for and against for many, many years, and that's Terrence Malone in Dodge City. And I don't know all what happened there. I've heard rumors, but whatever the case may be, he was given a 90-day suspension approved by the disciplinary administrator's office in this court. But yet today, the DA's office wants Mr. McVey to stay out for a year. Now, he's going to talk to you.
How do you reckon, you keep talking about that's disciplinary
I can't
administrator?
hear you.
You keep just mentioning that that's been the posture of the disciplinary administrator from the get-go. I think that's how you said it. And that's still the recommendation. You had an opportunity to put forth recommendations before the hearing panel, and that didn't occur. And you have a group of independent lawyers, Mr. McVey's peers, who recommend a 1-year suspension. How do you respond to that? Heard all this evidence, and that's what they recommend. And it's a panel of experienced lawyers who are recommending this, who have experience being hearing panel members. What's your response to that? And comparing it to other cases isn't very helpful, but tell me, why didn't you take the opportunity to argue this and recommend some sort of lesser sanction? You didn't do it.
I have. I'm going to answer your question. All right. And if it squeezes tight for my client or you find it offensive, I apologize, but I'm not here. All right.
We're not too easily offended, so go ahead.
Well, if I can't tell you how I know this, nor can I tell you that I can prove this, but the way that the hearing handles is postured now, in addition to a court reporter, the office of the disciplinary administrator has an employee, I don't know, staff member, attorney, that I don't know, and they sit down and they take down everything also. And it's my understanding that they write a preliminary opinion also. And it's my understanding that in that preliminary opinion, they incorporate the facts as they took it and as they recalled it. Now, if you look at the opinion that was issued, there's like 40 findings of fact or more that normally, at least, I guess to show my ignorance, when I was on that panel for 14 years, we didn't write them that way. And I'm telling you that I think that the influence of the disciplinary administrator can, in some instances, influence that final opinion. But never have we ever said that we wouldn't accept public censure. And that's still our position to this day. This young man should not be suspended for a year. Let me tell you something, and he'll come up here in just a second. The background of what he went through in working for Attorney Brock McPherson is a whole nother matter that you're not here to decide, nor should I dwell on it, but it's not perfect. And he had no ongoing practice other than take care of McPherson's clients, which included they had a computer printout of some 44,000 plus collections that they would handle. And that's essentially what he did. When Brock McPherson told him to leave and give him his keys and clean out his desk, and it's in the report, that's when, notwithstanding that Mr. McVey had paid for part of the firm, which was just summarily disregarded, McVey didn't have anything else to turn to except start making a living. He has no children, he's married, his wife is disabled. And so he started doing appointments work, criminal, both felony and misdemeanor. And that's what he's doing it now in some 11 counties. He's also a judicial or a city prosecutor. And he's doing the best he can. He's a valued member of the bar. And I wish we could have made a better showing, but if you want to go through all the records, we could furnish them to you, but not once did they ever come off of this suspension long before it got to the hearing panel. Now, I'm going to try to comply with our time, which apparently hasn't been done too often today. I'd like to have Mr. McVey come forward if you don't mind, Lee. Step right up. Announce yourself and tell them how this has affected you.
May it please the court. My name is Jeff Lee McVey. I go by Lee for whatever reasons my parents could only explain. My business address is 1201 Washington, Great Bend. My Kansas Supreme Court number is 15501. I've admitted from the outgo of this case that I violated 1.15. I've also admitted that at the time I was handling Miss Keenan's, MK's rental properties and her escrow account, that I felt like I was a real estate manager and not representing her as an attorney. Initial investigator, Mr. Schultz and Burscheit and the DA's office has made it very clear to me that I was wrong in making that belief or that assumption. And I acknowledge that and I regret it. And I do apologize to this court for taking his time for being here today as a result of that. However, I would also ask the court to consider or keep in mind that when Mr. McPherson asked me to clean out my desk on May 29th, I've been with him for 27 years. I had entered a buy-sell agreement with him in 1997 and paid him in excess of $25,000. He walked in my office, said, "Pack your desk and get out." Kept all my files, including those files that I prepared and kept over the years for MK. Those files did contain the appropriate paperwork for Ms. K and her real estate properties and the escrow account, because at the end of every year, she needed for her own accounting purposes how much was received, how much went to interest, how much went to principal, and those were always provided to her. However, after Mr. McPherson cleaned out my office and told me to come pick up the boxes that he had packed for me, I went to the office. They were sitting in his front lobby. That's all I was allowed to take. I did not have access to those records beyond May 29th. Any regret? In any event, I do regret the misconduct, and I can assure this court it will never happen again. And part of that assurance, I'd point out that I have 27 years of practice in this state for our disciplinary history. I believe that speaks to my integrity. When I agreed to help MK with the escrow account, I did so at her request. When she sold her rental properties in 2015, I asked her to find another escrow agent because I was not charging her to be her escrow agent and collect those funds, write those checks for taxes and insurance or anything else involved with that account. She did not want to do so, so I kept handling it on her behalf. At that time, she said, "Well, rather than write me a monthly check, I will call you when I want a check." And that's what we did from 2015 moving forward. She contacted my mother in the summer of 2020. I immediately got a check to her for the amount she requested because I did not have access to my records going on the 9th of 2020.
Put her money consistently in the same. And how are we supposed to look at those funds for personal items at Walmart and grocery store?
It does not look good, I admit. I'm embarrassed to admit this, but after I signed the buy-sell agreement with Mr. McPherson in 1997, I did not receive any further raises from that office. 97 to May 2020, making $52,000 a year. About 2014, he had quit paying my monthly expenses, which were running around $500 to $1,000 a month. The firm owed me in excess of $15,000 in expenses. Frankly, I was in a tight spot financially. I guess I rationalized it to myself that, well, I'm her real estate manager. I will get the money to her when she asks, because she hasn't asked for it yet. So I wrote the checks. That, or admit that here today, but I'm being in all candor with this court.
What about the failure to provide the documentation? Strike me as it's an uncontested fact in this case that your failure to provide documentation amounts to bad faith obstruction of the disciplinary.
I didn't have the documentation from my files that were at McPherson and McVey law office. Those were not provided to me when Mr. McPherson. I didn't have.
Let's assume that you've got a defense to that. The panel makes the finding, you don't contest it. So when it comes to us, that part's done.
That's correct. And again, in all honesty with this panel, that was advice from my counsel and from other counsel that we conferred with, not to findings and just move forward.
They exist? Records.
Yes, I kept detailed records of what came in, what date, when it was paid out, how much went to interest, how much went to principal. And I had to provide an annual yearly accounting to MK's accountant reflecting that for her tax purposes. I kept the records. The animosity between myself and Mr. McPherson during the last 5 years of my employment there was very high. In the event, I have served on the Great Bend Housing Authority Board of Commissioners for approximately 10 years. I've been Gordon Belt Humane Society. I've coached baseball, Little League Baseball, and Golden Belt Babe Ruth Association previously. Then I'm accepting felony appointments in 11 counties in central Kansas, as well as misdemeanor and child needed care cases. Unfortunately, there's a demand for that kind of legal coverage in that part of the state. I'm doing my best to try to fill that void and help the people that need help with their legal. With that, I would point out that, again, I disagree with the panel's finding that we did not make a recommendation at that time. Mr. Burscheit, I thought plainly requested public admonition. And I do admit that.
First, Justice Wilson, in response to your question previous, Rule 217A does not require adopting of a complaint before a subpoena can be issued. It just says an investigation under these rules. Not all 1.1 violations are created equal. As Mr. Burscheit was mentioning different cases, didn't talk about kind of what the 1.15 violation was. And there's lots of different types of 1.15 violations, lots of subsections. As Justice Rosen pointed out, comparing cases sometimes is of little value. I do think that there are some, if we dive a little bit deeper on some of the cases, we can find some helpful information. If you look at the Shumway case, I think the Shumway case is, let's see. 269 can 796, it's from 2000. In that case, the court ultimately stated misappropriating client funds is one of the gravest offenses against the public trust a lawyer can commit. And that's what happened in this case, particularly in MK's case. The funds were received, they weren't properly safeguarded, they were spent, and then other funds were paid to her. I think he paid August 6th, and he received the first amount of funds the end of January earlier that year. And in the Shumway case, it's also even more relevant other than just that one line. In that case, Ms. Shumway took an advance fee within days. She spent the advance fee prior to performing any legal work whatsoever, which is, I think, is tantamount to what happened in this case. That case ended with a 1-year suspension with conditions. And In re Ritmaster is another one that's somewhat similar. 299 can 804 2014 case. In that case, the respondent failed to provide an accounting of funds held on behalf of the client and failed to cooperate in a disciplinary investigation. Again, a 1-year suspension with a reinstatement hearing. In that, I want to comment briefly on the respondent's arguments about he didn't have his records. He never asked Mr. McPherson for the records. Now, maybe Mr. McPherson would have said no, but he never asked. He never asked the office manager. He never asked Mr. McPherson. He never had contact with him again after he left that day on May 29th, 2020. Additionally,
In preparation for the hearing, and it's been a long time since I was on that side of the deal, but both parties have the ability to request subpoenas from the panel.
correct. The,
I didn't, your office just subpoena the records.
well, like as I mentioned before, we're under Rule 1.15 is required to have the records. I actually have a whole, I'm gonna go get my argument because I have a whole page on it. Listen to that. They're required to cooperate in disciplinary investigations. It's a much faster method if the respondent can simply get the records, provide us what he has. If he's already got an accounting done, if he maintained the records as he went along, if he simply asked Mr. McPherson for those and provided them to us, it's a lot faster, it's a lot cheaper, it's a lot more efficient.
Did you know about the toxic relationship between respondent and Mr. McPherson?
When Mr. McPherson filed his complaint, it was pretty clear that there was a toxic relationship. The complaints included a lot more complaints than the ones we proceeded on. The two that we proceeded on were the only ones that had, that we found to have merit.
When you're saying it was just a lot easier for him to go to Mr. McPherson, I mean, it was clear that this was a toxic relationship, right?
Well, I think it's reasonable for him to ask for his records. And if he didn't get what he needed to have in order to practice law, he should have asked his former employer for the additional records. During this process, I contacted Mr. McPherson's office and I asked for the records, and he provided me with a receipt book, which was immediately forwarded on to Mr. McVey.
So you did ask for some records.
I asked for all of the records from Mr. McPherson. And he provided the receipt books. And if Mr. McPherson had taken the receipt books and combined that with his bank account, he could have created an accounting, but he didn't. In fact, while he was testifying, Mr. McPherson was asked, Mr. McVey was asked about the records that he did provide, which can be found in Exhibit 6 and 7. And he said that some of those he received from online banking where he was able to just download.
I think I'm confused.
Okay.
You talked to Mr. McPherson.
I talked to Mr. McPherson's office assistant.
Okay. And that person provided you records, the receipt books,
Correct.
but could not provide you the records that respondent is talking about, which were the accounting for MK.
Mr. McVey described the accounting as something called, what he called a backing, which was a piece of cardboard with like a clip to hold paper on it. And he said that he had a backing, which with his accounting. After I received the receipt book and Mr. McVey communicated that his backing wasn't included, I asked for that and she said there was no such thing in the files. So I received what they provided to me, I provided to Mr. McVey. But my point about the bank records is that it was his personal bank account. He had access to the bank records. He had online access to the bank records. In fact, he printed off some of the bank records to provide what became Exhibit 6 and 7. And when he was asked, why didn't he just print off all of the banking records from that time period and create an accounting? He said that he printed off what he thought was relevant. That's on page 60 of the transcript. And what he provided was simply 1 month during that time frame. And what we needed to, the complaint involved the January through April payments. So what we really needed to have was a time period of starting in January and going through whenever he made the payment to MK, which was August 6th.
Want to make sure I'm clear. But you've got this, so from McPherson's office, you've got this ledger that shows the receipt of money being delivered to the office, right?
It's not a ledger, it's like a receipt book. It's just like a carbon copy of receipt. So there's not like a running balance or anything. And it involves other, I think it involves other receipts.
But it shows the incoming of money.
Correct.
Money was then deposited into bank accounts controlled by Mr. McVey.
Well, yes and no. He says eventually it was deposited, but he also testified that he kept that cash in his drawer and that cash was commingled. So it was.
Was the money deposited in any banks that were controlled by Mr. McPherson?
No. Just briefly, as I'm out of time, unless there are additional questions. You have a question?
I do have one question.
I can tell.
Your opposing counsel made what I guess I would describe as a rather extraordinary statement. So I wanted to ask you about it. Do members of the disciplinary administrator's staff assist the hearing panel with drafting final reports?
In my previous job, I was counsel to the Kansas Board for Discipline of Attorneys, and that was my job. So while I was housed in and that job is now currently performed by Crystal Bokens. So while I was housed in the disciplinary administrator's office, it's the board has complete control over her work. She makes a draft.
So even though that you might describe that as a technical employment relationship, there's a wall of separation, if you will, between the panel and the staff of the panel, and then the prosecutorial wing of your office. Is that correct?
Physical as well as practical.
So they don't, the counsel to the panel doesn't talk to the prosecutor about the case.
No.
Okay. Thank you.
And I'm very familiar with that role since I served that role for 23 years.
Yes, I knew you were. Thank you. So that's why I thought you would be helpful in clarifying that.
Right, and there's no change to that role. I mean, I remember I served on 1 or 2 panels back when I was in private practice, and that was a long time ago. I'm just saying there's no change in that, the way that relationship has occurred since back when I was familiar with it.
No change whatsoever. I do think it's important that we have a reinstatement hearing in this case, and that's because I still think that respondents should provide an accounting of MK's funds. And so that way we can know whether or not she was made whole. He has the receipt book, so he knows what money came in. He has access to his bank records. He indicated an unwillingness to get those bank records because of the charge involved. However, he also talked about the online access. So I think he should be required to establish that he has made her whole by providing that accounting that was asked for such a long time ago. And never move my papers around because then I can't find them when I need them. And I think if there's no additional questions, I'll rest.
I see none. Thank you. Thank you to both or all of you for your comments and arguments today. We'll take this case under advisement. Call the final case on the docket, 125622 in Ray Marks.
Justice Lukert, members of the I apologize. I need to slow down. So Chief Justices, Kathleen Selzer-Lippert, Deputy Disciplinary Administrator, half a petitioner, Disciplinary Administrator's Office, present and ready for argument. I would request 3 minutes for rebuttal. This case is an original action in attorney discipline, and the parties bring this matter to you in Form 23 for this court's consideration. This case involves reciprocal discipline. Mr. Marks was originally licensed in Kansas in 1987. Close in time, 1987 or shortly thereafter, he was also licensed in the District of Columbia and Maryland. In 1998, Mr. Marks changed the status of his Kansas license to inactive. So the underlying case or the underlying disciplinary matter in this case actually stems from the District of Columbia. So in the District of Columbia, there was a complaint filed, a contested evidentiary hearing, and ultimately the District of Columbia Court of Appeals issued a disciplinary order finding that Mr. Marks violated several of the District of Columbia's disciplinary rules, including in the District of Columbia 1.1 competence, 1.3 zealous advocacy, 1.15 safekeeping, 8.4C conduct involving dishonesty, and 8.4D adverse to the administration of justice. The District of Columbia issued an order of discipline for 1 year suspension with reinstatement. Condition of reinstatement would be legal education. When that disciplinary order was issued, it was the disciplinary authority of District of Columbia provided it to both Maryland and to Kansas discipline. In Maryland, Mr. Marks, along with a joint petition for indefinite suspension, was tendered with the right to petition for reinstatement after 1 year, and the Maryland court issued the suspension on September 13th of 2021. Mr. Marks did not report the Maryland discipline to Kansas. So the parties stand before you today asking the court to accept the findings of fact, the rule violations, the corresponding rule violations in Kansas to the District of Columbia are 1.1 competence, 1.3 diligence, 1.15 A and B safekeeping, 8.4C and 8.4D. The joint recommendation of the parties is to is for a 1 year suspension to run concurrent with the Maryland discipline to start on September 13th of 2021, and a requirement to undergo a reinstatement hearing.
Okay, so how does that work? If it's September of 2021, September of 2022, so it would already be over. So he's already ready for a reinstatement hearing, right?
So it would be sometimes it's referred to as a retroactive institution of suspension. It's not often, but there are a couple of different cases where this court has issued a retroactive suspension. That the cases that immediately come to mind, Henry Brock, which
Well,
is
I get the part that it's retroactive, but you're also requesting a reinstatement hearing, correct?
yes. And the reason for when at the time that we developed this summary submission, at that point in time, he had not been reinstated in either the District of Columbia or Maryland. After we signed the summary submission, I believe that, and in fact, Exhibit E, Mr. Marks' Exhibit E, he has been reinstated in the District of Columbia, but he has not been reinstated yet in Maryland. And
That change your position about whether a reinstatement hearing is required here?
I think that is a change, a substantive change that is important to consider. And if he has been reinstated in both those jurisdictions, a reinstatement hearing may not necessarily be required if he's been reinstated. But at this point in time, he's been reinstated in one, but not the other jurisdiction.
And then how does that affect the fact that he's been inactive here the whole time?
So there is sort of a couple of different issues ultimately for Mr. Marks, because if he were reinstated, if we had a magic wand reinstated tomorrow, he would still have an inactive license, and also his inactive license was administratively suspended, I think in 2011, for failure to timely register and pay the required registration fees. And although I'd have to look at my notes, double check exactly what the administrative of it. So if he were reinstated, it would be to inactive and administrative suspension, and he would have to go through the steps that are required in attorney registration 206 rule.
That's fine.
Assorted rules related, because there are a host of rules connected with reinstatement of an administratively suspended license. That answer?
Yeah, but you're not prepared now to. Because it seems like if we, if you submit to us now that you're still requesting a reinstatement hearing, and we end up doing what you've asked, and then he gets reinstated in the other jurisdiction, Maryland.
I think it's important that before allowed to reinstate in Kansas, that he needs to be reinstated in both the District of Columbia and Maryland. He's been reinstated in one, but not the other.
You would request us if he does like an update, and then we would put in the order that if he submits something that he's been reinstated in Maryland, then he would not require reinstatement hearing here.
That would be appropriate.
Wanted to ask about the Rule 1.3 violation, the diligence violation that's tagged to, I understand the failure to pay the taxes in the rule. Not sure I understand the failure to maintain a safe and living accommodation, the habitable property part of that. How do you see that as falling under the attorney's responsibility for diligence purposes?
So the facts supporting it for the Kansas rule violations are drawn directly from the discipline or the District of Columbia's disciplinary finding. The District of Columbia, the rules are very similar, but they're a little bit different. So for instance, in District of Columbia, Rule 1.3 is zealous, a requirement for zealous representation and seeking lawful objectives. He had, and this was part of the underlying case, is that he had a duty as part of his trustee duties and responsibilities to care for the subject of the trust. And that was one of the disputed issues that as part of the evidentiary hearing, and then ultimately part of the determination by the ultimate order in the district. Questions, I would yield.
Thank you.
Good morning, again, Chief Judge Lucan and justices of the court. I am honored to be here. This is actually my first time in the Judicial Center, although I regret it's under these circumstances. I am Isaac Marks Sr. I am appearing pro se. You have the record, so I won't unnecessarily start from scratch with that. Other than to say that this all came about from two mistakes that I made. The first was I withdrew money from the trust account, not knowing. And you have Bank of America here. I had the trust account at Bank of America. I had personal accounts at Bank of America. And I had a couple of business accounts at Bank of America. I made a personal withdrawal. I gave the teller my debit card. I did not know it then, but I am painfully aware of it now. She could see all of my accounts. And I said, just take it out of the checking account. She took it out of the trust account, not my personal account. I didn't catch it. I should have. I didn't. When I caught it, eventually I disclosed it and I paid 10% interest. I know that's a big no-no. I knew I was going to be punished for it, but I disclosed it. I was wrong. I had nothing to hide. I was willing to take the punishment. The second mistake was my arrogance. I did not have a good relationship with the guardian for the ward. I petitioned the court for a guardian to be appointed. She had she had a shunt put in her brain as an infant. She had encephalitis, which caused anger management issues. As she got older, she became hypersexual. Her grandmother, who was my client, took care of her. She was her caregiver. I had represented the grandmother since 2004, just to give you the background, because this is not in the record. Her grandson was in jail and he had a colostomy. He had been attacked and it caused him to have a colostomy. While he was in jail, he had it reattached. He clotted and died. Grandma came to my firm. I represented her. We sued the district and got an award. And I became her attorney. She was an elderly lady. She had her granddaughter. Her grandson was gone. Her granddaughter's mom had died early in life. I would go by on Saturdays and sit and have coffee with her and talk with her. I'd take my son. And she had no one really. So I was her attorney, her friend. And so she had this money. And I explained to her, this is your grandson's money, not yours. And she had a house on Georgia Avenue. I don't know if any of you have ever been in the District of Columbia. It's a major thoroughfare. It was a tear down. It was livable, but no one was going to rehab it. The neighborhood was changing. And to this day, all the houses on that block, with the exception of 2, have been torn down and they built condos, which I knew they were going to do. So anyway, I drafted the trust agreement that I was ultimately held responsible for. I drafted it. I knew exactly what was required and where it was held against me. Grandmother died in 2009. We know that in 2008, there was a recession. The house that she lived in, she had a written offer to buy for $565,000 in 2006. I had the house appraised in about 2010. It appraised for $250,000. I couldn't sell that house for that because it would not have allowed the granddaughter enough to live in. So I held on to it. It had a reverse mortgage on it. The granddaughter could live there without having to pay anything because the reverse mortgage just increased incrementally each month. The guardian was taking care of that. I did not have a good working relationship with the guardian, and that was my fault. I should have been more mature. I was arrogant. We just clashed. And the other items from which I was charged, looking at individually might not have been an offense, but because of that withdrawal and the totality of all the other small, what I call small items, I don't mean to minimize, got me in this situation today. This all happened between 2010 and 2012. Bar counsel did not file the charges until 2018. My witnesses were no longer, either they had moved from the area or they didn't remember. My attorney said, Isaac, you're going to be suspended for the withdrawal. If you keep fighting these smaller items, they're going to think that you just don't get it. And they're going to drop the hammer on you. So I accepted. I caused the situation from which all of this arose. So I accepted it. Because as he said, I knew I would have been suspended. For the withdrawal, it would have been anywhere from 3 to 6 months. But with the other items added in, it turned out to be a year. I have to share with the court, I heard the earlier case, I heard it mentioned the peer review panel. I'm on Bar Counsel's peer review panel, and I have been on there for the past decade. I'm an auditor for the court, Prince George's County Circuit Court. When there is a foreclosure of property, the foreclosing attorney has to submit an account for the funds. That comes to me to review. I then work it out with the attorney. I prepare my own account, and I file that with a prepared order to the court. When the case has the court has a difficult business case where it's just crunching numbers. I often get appointed to be the, we call it, well, auditor, but that's a different function for the auditor, that the court sends that to me. And I work with counsel to get it worked out. Again, it's like with the auditor review of the account, I take both sides, I can subpoena, I take the evidence, I say, hey, folks, this is what I have. Tell me if you disagree. And we sit and work it out most of the times, if we work it out or not. I submit my findings to the court. I will say, I have not been asked to resign from any of those positions. On the peer review panel, they said, we understand, we hate this. We're just not going to call you and assign any cases to you. Not that I could hear though. The same for the court auditor in those positions. I take pride in practicing law. I'm not one of those who's a frustrated attorney who wants to be a writer for anything. I enjoy the practice of law. I took the Kansas bar. I did not mean this as an offense when I had written it earlier. I took the Kansas bar because my mother asked me. I hadn't planned to. I left Kansas in '79, going to school, and I stayed in Maryland. And I said, I hadn't planned to, and she got this look on her face. I'm like, why? She said, well, I thought you might want to. So I did. I subsequently learned she asked me so she would have bragging rights over her sister, my aunt. I'm just glad she's not here. To see me have to go through this. I'm sorry, I didn't expect for it to bother me like this. But as I'm serious, I take my responsibilities as an attorney. This is my 36th year practicing. I often mentored attorneys who didn't practice with the best practices. I have talked with attorneys freely about my suspension, so they would not make the same mistakes. So anyway, I just want to impress on you, I fell short of the mark of that. I have been reinstated in the District of Columbia. In Maryland, I filed my petition for reinstatement. Bar Counsel has consented to it. I'm simply waiting for the court clerk to process it. He has to submit a certificate of no opposition with the order to the court. I had hoped that it would be done by now, so I could have updated my material to say I'm reinstated with in the state of Maryland. For Kansas, I became inactive. I went into private practice or solo practice. I left my firm in 2012. Fall of 2011, I was busy trying to wrap up matters. I paid the fee late. I paid it though. They sent the check back to me. I said, oh, why did they just tell me I owed more or something? So anyway, and then I went into my solo firm and I did not repay it. I take that back. I sent it back a couple of times and it was sent back to me. They said, well, you now have to fulfill the CLE requirements. I said, CLE? Don't have CLE in Maryland or DC. So I opened my practice. It was just me, my solo practice. I didn't get around to it, and those CLE hours increased every year. So they are probably in 2022 about 88 hours that I'm not going to fulfill. So I would like to be, I would like for when the suspension ends, have the opportunity to be able to apply. In reality, I probably will not. So with that, if you have any questions.
Thank you, Mr. Marks.
Thank you.
Justice Biles, if I may, just, I guess, refer back to your question. Back to Rule 1.3, there were several facts supporting that. One was the failure to provide an accounting for the trust in October of 11 and 12, and failure to pay taxes for the house in, I think, 2011 and the first half of 2012. So there, in addition to the failure to provide, maintain habitable property that your question was concerning, there were several other factors supporting that.
I understand. Let me ask you about the reinstatement part of this. And I'm just shooting off the top of my head here, but it seems to me that instead of ordering a reinstate, why can't we just say something like, once the all reciprocal anyway, once Maryland does whatever it's going to do and reinstates the respondent, that we order that he return to his status prior to this without all the trouble of having to pay for a reinstatement hearing. I mean, why don't we just go back to the status quo?
And my response to that is certainly that is appropriate under the summary submission, that one of the summary submission rule 232, I believe it's subsection F. Our submission is advisory only, and the court has the latitude to impose what it views as the appropriate discipline. And some facts have changed since we originally, I guess, put ink to paper on the summary submission. At that point in time, I believe it was the end of July. I think it was July 29th. I could be off a smidge. But at that point in time, while it was hoped or perhaps anticipated that the suspensions in both jurisdictions would be lifted, that wasn't what we knew at the time. Since then, we have now a reinstatement in the District of Columbia and a pending, might be the best way to say it, reinstatement in Maryland. So I guess I'm not sure if it's appropriate to change my recommendation since it's a summary submission, but to the extent it is appropriate, a final order from the court that said must show that he is reinstated in both jurisdictions.
I'm just trying to make sure that if we did something like that, we wouldn't create some other problem. I appreciate we've got the muscle to do this, but I'm trying to make sure that it doesn't create some other difficulty. It just seems like the shortest distance between 2 points rather than going through the rule process of reinstatement in Kansas, which is still going to end up with the respondent having to do the like that's an easier way. I don't know that there's something I don't know.
Nothing immediately comes to
Okay.
mind that would create some other constant. I see my time is out. If I may have a moment or two to conclude. Mr. Marks, one of the remarkable things about this case is he has been very cooperative in working and coming to a resolution in this case. I'm not sure, I know that he provided some additional sort of background and perspective. I think from my perspective, the rule violations in DC were a little bit more serious than maybe immediately portrayed. Certainly, he described the commingling. But in addition to that, or if that is not given as much weight, there were also issues with respect to 1.15 related to what the District of Columbia found is that he allowed 2 Social Security checks to sit in the trust account between 2009 and 13 without providing the money to the beneficiary or using it for the beneficiary's benefit, or trying to resolve the apparent concern that he articulated. There were also the 8.4C and 8.4D. 8.4D, the respondent's failure to properly administer the trust caused the probate court to hold 2 hearings and appoint an auditor master in order to correct the mistake. So it is serious. It was serious. And I think a really important mitigating aspect of this is his cooperation, which is one of the reasons why I thought it was appropriate to do the retroactive questions. I won't yield my time because I've used up.
Thank you. Thank you to both of you for your comments today. We will take this matter under advisement. Court is now adjourned.